It's time for the Court Report, our bi-weekly segment with the Upper Midwest Law Center. They are a nonprofit public interest law firm on the front lines, dedicated to defending constitutional freedoms and the rule of law.
Love having him on the program. He is the president of the Upper Midwest Law Center. He is Doug Seaton. Doug, a Merry Christmas to you and yours, sir.
Merry Christmas to you as well, Al, and your family. Glad to be with you.
Oh, just absolutely love that you'll do this for me, especially like you say on Christmas Eve. Been asking folks, little sidebar. See what I did there? Little law thing. Little sidebar. What's your favorite Christmas tradition? Do you have one? Do you have something you and your family just always have to do?
Well, we always have a little Christmas Eve celebration with some treats, and one present gets opened, and then the rest Christmas. The rest Christmas Day.
See, you and I, we get along well, but I've also had one other guy on the show today. We were staunch. No Christmas Eve presents. Wait. So you couldn't hold off. I get it. It becomes a thing, and then once you do it 1 year, it's every year. You got to hold fast. That's okay. Good for you. As we're getting near the end of the year, and we won't get you back on until 2026. How do you think, if you're giving yourself a report card, the Upper Midwest Law Center is done in 2025? You've had some of just the most large cases that I can imagine. This thing with binary trigger, we'll talk about it. How do you think your year went?
You know, we are very, very excited and blessed to have the year we've had. We had some transitions. We had a lawyer leave, but we've got more lawyers now than we ever had before. So there's 6 of us, and we're ready to take on the bad guys at every step and get things changed in the right direction. It's been exciting. Many victories, as you said.
Yeah.
We've had 60 cases in total since our founding in 2019. And that's a pretty big order. And we've won a lot of them. We never thought we would win as many as we have, both in federal court and in state court as well.
Well, let's talk about some of the big, if you don't mind, catching us up for what has happened in 2025. I personally think, not that they all aren't big cases, especially it's about you, but this omnibus bill thing that you guys are winning, I mean, I don't know if it's done yet, but you won for the Minnesota Gun Owners Caucus, I think it was, right?
That's right.
You won that binary trigger provision they put in the omnibus bill. That can't be in there. It's one bill, one subject. You won that case, right?
We did win that case. The Minnesota Gun Owners Caucus no longer has to deal with this binary trigger ban, which was probably unlawful on other grounds, the Second Amendment grounds. But we challenged it, as you know, based under our state provision, which is akin to that in almost every other state, that you can't load up a bill with unrelated things, pass it, and have everybody not know what's in it and be subjected to it. That's the rule of law in most states. I enforced it once 20 odd years ago with Governor Ventura, that far back. And the court said, don't ever do it again. And here they are doing it again. So we have a bad legislature misbehaving, and we have to call them back to line.
What I think bothers me about that, sir, I love that idea because it should be one thing on one bill so we can all discuss it and there's no hiding for our legislators. That's my opinion. But what I don't understand is, so the binary trigger law gets pulled out. They said, nope. But that was a 1,400 and some page bill. There's a whole lot of other stuff in there. Is that all still standing today? It didn't pop the balloon, if you will, and everything came out?
I wouldn't say standing. I'd say teetering. But you're right in the sense that this court said, I've only got one client in front of me, one plaintiff with one issue, so I can give them a whole remedy and relief by taking that out. So that is what he decided to do. Now, he invited the appellate courts because he knew this was going up, and it is. I'll tell you more about that.
Okay.
He said, everybody, the rest of the courts should take note and strike this all down. And if you're out there and you have a problem with this bill, Minnesotans, you should step right up and sue and hack it away until it's gone. He was very incensed about this practice, but he didn't feel he had the power to strike it all down at the district court level.
Okay, so at the district court level, he doesn't have that power. Okay, I guess I can see that. Yeah. Does the next step up, or let's say and I don't know how many, let's say there's 100 things in that bill. Does the Upper Midwest Law Center have to do 100 cases to get each one thrown out, or does the court look and say, okay, by the 4th time we got the program here? You know what I'm saying? It seems like you're going to have to work a lot.
We sure hope we don't have to do it that many times, because But if it takes that, that's what we'll do. And we have another half a dozen potential plaintiffs who are interested, and we're going to be talking to them over the next several weeks to put cases together to to do exactly what the judge invited, which was to hack away at it until it's gone. But we believe the appellate court and the Supreme Court do have the authority. They've got the standing decisions, holdings from the prior Supreme Court of Minnesota saying this is wrong, it can't be done, and they should strike it all. We are arguing for that in our cross appeal. The state appealed, otherwise we probably couldn't have appealed, some would say, because we won, but they did appeal. So our cross appeal says, court, please strike this all down. You should do it. You know you should. You warned them before. This should not happen again. We had a 300-page bill when I did this 25 years ago and challenged it successfully. Now we've got 1,400 pages. We got to get to 3,000 before the court says enough? No, we don't think so.
Let me ask you this, because I love your thought on what the court thinks, which is probably going to get you in trouble. But is there a timing thing on this? And what I mean by that is the legislature passes this bill. Maybe the trigger ban you can pull out, but some of it's going to be spending. Some of it's going to be implemented before it ever gets, if you will, pulled down. Will the court say, well, it's too late, it's already been implemented, so I can't play with it? I mean, can they retroactively pull a bill apart? Or are they sitting there thinking, we have to do this now, because if we don't do it now, it'll start getting implemented? Does the court take the timing of those things into consideration?
Yes, it does. And there are times when a court will say, well, this is moot now because it's all over and done with. We don't think that's true here. And we do think, even though there may be some pieces of it that are kind of midstream in some sense, we think the right course of action is to strike it all down and let the chips fall where they may. And the legislature can pick up the pieces and do it right. If there are things that have to get re-upped or repassed, they can start over and do it the way you just said a minute ago. Sure. Let's have an issue per statute, the way it's supposed to be. And I guess I'm looking at, because a lot of that stuff will start happening here as the first of the year. Planned Parenthood, or not Planned Parenthood, paid parental leave, that sort of thing. Yes. Paid family leave. But the legislature doesn't get in until February this year. So there's that gap time that even if the judge says, you're right, get rid of this whole thing, there's 6 weeks before they can come back and vote on things and start putting some of that back together. Does it just all go away if the Supreme Court says, no, you're wrong? Not you, the state. The court has some latitude to fashion what the remedy is, what the results are going to be when it's unconstitutional. I mean, the usual rule is at the U.S. Supreme Court level, if something's unconstitutional, then it was unconstitutional from day one. And so that does mean it gets unraveled and they have to pick up the pieces. And that's I guess our view is that's a mess they made. Sure, they have to clean it up, but it's not the plaintiff's fault that we're in that situation. It's the legislative majority's fault that we're in that situation.
Do they give you, just before we go to break, do they give you any timetable? Do you have an idea that when they're going to read that appeal from you, when they're going to send a summary judgment? Do you have any idea on the timetable on that?
They will finally give us dates. We tell them when we can't be there. Okay. We've filed the brief, so everything is in place now. And what they have to do is set a date for an argument. We're very hopeful it'll be soon, obviously, for the reasons you said. Better sooner than later to have this taken up again.
All right. This just from Al's point of view, this could change the way they do everything at the state capitol. There's no more hiding behind, I voted for this bill, even though I didn't like all this other stuff, because I really it'll get rid of all that. We'll have a much purer thing, but it's going to make them decide what to put up and what not. You're not going to have 1,400-page bills. This could change the way we do stuff in Minnesota. Doug, I am so excited that you people are able to pull this stuff out. This is huge and exciting stuff in Minnesota. Oh, you've got more of it. I got to go to break. When we come back, I want you to catch us up on a whole lot of stuff you got going on. We'll do that right after this with Doug Seaton, the Upper Midwest Law Center, and the Court Report.
Are you tired of government overreach and the constant threat to your constitutional rights? The Upper Midwest Law Center is your legal sword and shield. We're a nonprofit law firm fighting every day to defend free speech, religious liberty, and the rule of law. We secure landmark victories that restore school neutrality, protect property rights, and hold government accountable. Our mission is to ensure liberty endures for all Minnesotans. So if you or your business is facing a constitutional violation, we want to hear from you. Learn more and support our work at umlc.org.
Are you kidding me?
You know that comment you said to the radio? The thing that we got wrong?
Clearly, Brussels sprouts are the worst vegetable.
Call us and let the world know your thoughts. 855-257-7469. That's 855-ALS-SHOW.
We've got him, Doug Seaton, in. He is with the Upper Midwest Law Center, talking about all the stuff they've got their hands in. Talked a lot about the one with the omnibus bill, but you've got so many things going on. Can you catch us up quick? What's going on with the two doctors and Walgreens?
Yes.
Where are we at with that?
Case. Yes, we have two pharmacists fighting with Walgreens and with the state. They're pointing fingers at each other. But what happened is the pharmacists for years had said, we can't handle, our religious beliefs say we should not be handling abortion drugs and drugs that are sex change drugs, basically.
Okay.
And that for a long time, other pharmacists were willing to pick these up if they came in, and others were handling them for them. And all of a sudden, Walgreens said, oh, no, we're not going to do that anymore. That's called a religious accommodation. It's spelled out in the law. They got to do it if they can, unless it's an extreme hardship. Mm-hmm. And all of a sudden, they stopped. And so we know it's not a hardship. It's just somebody got up on the wrong side of the bed or something and decided to punish these two ladies. And they're both doctors of pharmacy. They're good people, and we're fighting for them, and we're going to win this case because they have a right to have this accommodation. Walgreens says, well, the state's making us do it, and the state is going to blame Walgreens. They haven't quite said so yet, but I'm sure that'll be the deal. They'll point in opposite directions, and we're saying, whoever's to blame, you can't do this. If it's Walgreens, their anti-discrimination laws, accommodation requirements, you have to meet Walgreens. If it's the state, it's the First Amendment, and you can't do it either. You can't require somebody to do something against their religion when they've got alternatives and they can accommodate this without hardship. Sure. So we're going to win, but we haven't won yet, and it's going on now. Discovery continuing.
All right. Other stuff as I go through your website, which is just amazing to me. From 2024, you and the Public Interest Legal Foundation got together with something about voter registration and Secretary of State Steve Simon. Well, this is going to be huge with the election coming up in 2026. Give us what that is, and is that settled?
Yes, no, that one is ongoing now, on appeal right now. And what's going on here, and you've seen snippets of this in the news, of course, that the state refuses to release certain voter information. They claim, oh no, we're exempt from doing that. And you may have heard some of our colleagues at Judicial Watch and others have forced California and other states to give up the same data. And the Minnesota saying, oh no, we don't have to do that because we're exempt from that provision of the Motor Voter Act, as people would call it, Motor Voter Act. Right. And we're saying you shouldn't have any such exemption. You got to give us this. That's the fight we've got ongoing. So in many cases, we've got election integrity fights we've been fighting for a long, long time. And we've forced states and counties to comply with things. This is one of those fights.
See, that's just so funny because you do hear about it in the news, a snippet here and there. And folks, I'm just going to tell you, every time you hear something like that, you think, wow, how's that work in Minnesota? Go to the Upper Midwest Law Center. That's how I got them here. Every time I look up something was going on, it'd be them in the middle of it. And I'm just stunned by it. But I'm happy you're on top of that. Keep going. Then the last one, sir, because I saw it on your website, but it's just strange that it's still a lawsuit for me. You explained it to me.
Yes.
Alpha News and the Detroit Lakes Police Department and releasing the Senator Mitchell video from her arrest day. I got it. You guys were suing back in the day, but I thought that was all done. Is it not?
No, it's not all done. And strangely enough, we have this situation where the very body cam footage of the arrest that would be instantly taken, submitted and gotten in the public eye if a police officer were accused of something, all of a sudden it's a public official and we can't get the data. And we still haven't gotten it, even though the trial's already come and gone, sentencing has taken place, she's guilty, and we still don't get it. And nobody even asked to keep it from disclosure. The judge has just taken upon themselves to do this. We think it's mistaken, and we believe that ultimately the appellate court has to sort this out so that we have a clear rule in the future that you can't selectively hold this data back when you don't like the person, when you do or don't like the person who's the potentially going to be embarrassed by that footage. You've got to release it if it's publicly significant, and certainly it was at the time. To have a public official accused of burglary and not be able to get the camera footage is absurd, we think.
Well, explain this, because at the same time, there's that state trooper who there's a video of him, at a stop in Minneapolis, and that was all over the world.
Yes.
And then she gets caught, and that footage isn't coming out. Who is it that said it couldn't come out? Was it the city of Detroit Lakes, the police department? You're saying a judge said? Who didn't release it? I guess I thought it was the city, the police department.
Well, the ones who have it are, of course, the city, but the judge wouldn't let them release it. And that is not, we don't think that's appropriate. We don't think that anybody even has really argued for that among the parties, that is the city, Mitchell. But the judge unilaterally, sua sponte, as they say, decided it's not going to be released. We don't think that's appropriate, and for several reasons. But certainly the basic rule should be, if you've got footage obtained in this way, in a public way with the body cam footage, or the like, can be any similar kind of thing, and it involves a public official, and it's a matter of significance to the public. You should be able to get that data and get it when it's timely, and we didn't.
So this is a lawsuit against the judge, or is it just saying the judge you did? Who do you file a lawsuit against?
Well, we're filing the lawsuit against the city, and they're the ones who have custody of it, but they're stuck in a kind of the middle here, because the judge essentially would not sustain our demand to have it released. So they're sort of stuck in the middle. We believe the order will ultimately say from the appellate court that you must release this tape. And unless and I hope they don't, if they say it's moot, that'll be disappointing, because we need a clear rule for this. Now, you could say, well, it's moot now because she's already been sentenced. What difference does it make? But the rule is important for the future.
Well, it absolutely would be, especially as more and more stuff is videotaped. I mean, there's Ring cameras, there's stuff everywhere. You can't get away from it. We really do need a solid rule in this. I'm finding it interesting there isn't one yet. So do you know when they'll figure this out? Are you a year away from this? Is this 6 months away?
Well, this should be fairly soon because the appeal is underway now. We believe that it will be relatively quickly set for oral argument, and then we will ultimately, it still takes a couple of months after that to get a decision, but we should certainly have one in the spring. That ought to be the way it works, if not earlier.
I love it. Sir, if somebody thinks they've been wrong somehow, that they've got a case that has to do with the Constitution here in Minnesota, how do they get a hold of you and take care of business?
Yes, they should please get to us, and we'll do the best we can. If it's not a real case, we'll give them some guidance to help them with the issue they've got. But if we can take it, of course, we charge no fees. We take cases that can make a big difference for a lot of people. Upper Midwest Law Center, you'll find us in your browser if you want to look up the website like you've done, Al. Or people can send a check, send an inquiry to us, a letter. We've got a portal where people can put an email in the hopper to give us some facts so we can evaluate whether there's a case we can pursue or not.
Merry Christmas to you and yours, sir. I appreciate you being here. UMLC.org. I'm out of time. Appreciate you, Doug.
Thank you.
That's the Court Report with the Upper Midwest Law Center, with some insights into their mission to defend liberty and the rule of law. For more information on the cases and issues we discussed today, and to learn how you can support their fight, visit UMLC.org. We'll see you in 2 weeks for the next Court Report.